Hey, everybody. I'm Thomas Kenny. Welcome to the Moms for Liberty podcast, or whatever we want to call this, right, Jen? I don't know what it is.
That's right. Well, let's talk desegregation order. This series.
Yeah, that's what this is. It's like, let's talk desegregation order. Maybe this will expand, but basically, we want to spend a few minutes with you. I do policy and media here for Moms for Liberty. And before we get started, I just want to share with you a couple things. You can go to our Facebook page. I'll bring that up for you right now. We have the Moms for Liberty Indian River, Florida public page. There it is. It's on Facebook. Just search it out according to that title right there, Moms for Liberty, Indian River, Florida. Or just go to momsforliberty.org right there. Okay?
Yep, that's our national page. Yep.
That's our national page. So if you are outside of Indian River County, you can get contact with any chapter in your county wherever you want to go. You can start a chapter in your county if you do not have one. That's a great idea. And, just start from there. Okay, momsforliberty.org. Cool. We got all the fun out of the way. We want to talk desegregation order because, as you know, there's the racial equity policy that's been delayed. It was originally delayed until June 12th, the June 12th meeting. And the Department of Education informed the school district of Indian River County that this policy was illegal with a November 18th letter, correct?
That's correct. Yep, last year.
And they could have basically in, I guess, December put it on the agenda, and by January taken it, allow for the public comment and all that stuff, and by January have it removed. They chose not to do that and actually brought it up in February during Black History Month, for which one of the board members said, the optics of this doesn't look good. My thought was, well, you have a policy that promotes segregation. I think it's the perfect optic. It doesn't make sense to any, makes sense to you and I, but I guess not to other people who like to call their school system, what do they call it? They say it's systemically racist in the policy.
Yep, in the policy. And that's one of the things that the Department of Education flagged it for.
Yeah, they just did a word search, and one of our policies produced according to their word search, and they read it and said, this is illegal. So that's what happened, and here we are. In April, it was supposed to be repealed. They postponed it till June because they want to actually replace this policy with something they call inclusion. The superintendent said in Vero News that it's the same policy without the language, same intent, which doesn't make any sense because that means it's still discriminatory.
That's right.
So there we are. That's where we are. And there's also the achievement gap policy, which was passed last year under a shadowy cloak of darkness, I might say, because they brought it forth in July, and then in August, rather than having the hearing on it, they packaged it with two other policies and three policies, and that was during the time of the book stuff, where you were very adamant about the new policy regarding books and the library committee and everything else that was going on. And this policy never got discussed before its passage because it was buried with two others, one being the book and something else. That's where we are. Do you have anything to add on that? And then, of course, there's the restorative justice issues. You were on the committee this year for school disciplinary policy for the 23-24 school year. How did that go? What happened there that was a positive or a negative, or did anything happen?
That's right. Yeah, so we had the code of conduct, and it was open. It was open to the sunshine. We had principals there. We had community members there, parents there. We had a great representation for Moms for Liberty there. And we were able to remove anything that was restorative justice, restorative circles, restorative practices against the Department of Education standards now that, our school district is being governed. So all of that was removed. We tightened up the discipline. We made it when it should have always been, stricter discipline for the children, when they were, vaping or dress code, fighting, social media, with their cell phone usage. All of that is tightened up through the school district now. So again, with the restorative justice and the restorative practices, everything like that, the school district used to be governed under is now removed for the next school year.
Okay, cool. Basically, character and discipline. The bottom line of
That's
was the focus, and it seems like you got a lot of that done. A lot of the restorative things taken out, basically, too, as
That's
well.
right.
Well, that's cool, because here's the thing. I've been looking at this desegregation order, and it's, quote, 59 years in the making. It's really quite bizarre when you read it, some of the stuff. And you look at the beginning and the origin of it. The origin of it makes sense. The case was brought in 1964, probably before actual civil rights legislation was passed in November of that year, I believe. And it was brought to court in federal court based on Brown versus Board of Education, which I believe was 1954. So there's that. And the plaintiffs were Sharpton et al. It was a teacher in our school system, Idliff, I believe his name is. There's actually a picture of him in the where the school administration building where they meet for the school board meeting, right in the lobby there. And he was a teacher. I think, no, not Anthony Brown, someone else I was thinking of that was a student of his. But anyway, I digress. And so there's this whole thing going on with that. And it was basically when it was decided that the schools needed to integrate in 1965, the order was given by the judge. It was a different judge at the time, the original judge. Later in 67, a motion was filed again by the plaintiff saying, hey, they're not doing this stuff. What's going on here? At that point, a new judge comes in. His name is C. Clyde Adkins. He will be the judge presiding over this case for the next 32 years. And he's a very important person in all of this. And so he writes a desegregation order. Now, I want to bring that up because I just want to show people exactly what this is. So we're going to look at a few things here. There in the red. Order, a judge and decree that all the final decree entered here in April 1965 is an amended order from November 12, commencing with the 67-68 school year. All grades, including kindergarten grades in the public schools of Indian River County, Florida, shall be desegregated and students assigned to schools in these grades without regard to race or color. Every child eligible to enter and intending to enter any grade of public schools of Indian River County at the beginning of the 67-68 school year and subsequent school years may choose to attend any school in the county school system. So it is. The beginning of school choice was with desegregation. Isn't that amazing? So I've highlighted here in yellow who may exercise choice. Choice of schools may be exercised by parent or adults, person serving as the student's parent. It's an annual exercise of choice. So students come in, they can choose. There's a choice period, sort of like the way they do Obamacare, begins at this date. I think this one started in March. Yeah, March 1st, ended March 31st. You choose your school. You have a mandatory exercise of choice. Now, what does that mean? It's not the school system directing you. It's you directing to the school system. A failure to exercise a choice within the choice period shall not preclude any student from exercising a choice at any time up to 1 week before the opening of school. That's pretty amazing.
Right. So Thomas, I have a question. So
Sure.
when this was put, through the federal government and through the system, why was anything not done for 30 years? Could they not agree? Like, what kind of break it down? All of your research, all of your hard work. Why for that 30-year period was it not? Were we not taken care of with this case?
You're thinking like the 30-year period from, say, 67 to 94, which is about 27 years?
Right. With this judge, why did we not reach unitary status?
That's a big question, because one of the things I've been asking for the past couple of weeks is the actual, with this desegregation order, this 67 order, the amended order from the original, there was a request for a plan to desegregate the school system. So, and it's based on this stuff. So he had a public notice, school choice, then mailing explanatory letters of choice, so on and so forth. And we'll go through here. If their first choice was denied, a student could have a second choice. And then the assignment by a superintendent in default of choice by student. They had transportation. So if a kid chose a school, you had to get transportation for them as best you could. Now we don't have that problem in the county. We actually meet that. Officials not to influence choice, protect persons exercising choice, so on and so forth. Transfers for students. They could transfer from a school if they didn't like it. After they chose one, they could transfer to another one. Of course, transfers for special needs. These are kids with learning disabilities and things like that, or exceptional schools. Service and facilities, activities and programs. Basically, you can't discriminate kids from intramural activities and all those other things that kids do at schools. School equalization. Inferior schools have to be brought up to standards. This was definitely concerning the Negro schools being brought up to the standards of the white schools. And if you couldn't do it, you close them down because if they were in such poor condition. I don't know if that happened. These are the questions you're asking, and that's the type of stuff. They had remedial programs here, just below here. This purple line says remedial programs. That's after school studying to bring kids up to grade levels that they should be, expectations they should be. That's probably the beginning of the achievement gap. Okay. Faculty and staff and employees shall not be chosen by race or color, so on and so forth. But here's an interesting thing. This inside the green here, the dark green, wherever possible, teachers shall be assigned so that no more than one teacher of the minority race, white or Negro, shall be on a desegregated faculty. Shall be assigned so that more than one teacher of the minority race, white or Negro. So if they're a Negro teacher, 2 of them in a white school, white teacher, 2 of them in a black school. We're making schools integrated on all levels, student population, professional population, and instructional. That's the original order.
Wow.
It's different. And so there was reports on choice periods, because the judge had to see the most important thing. And then an explanatory letter. And this is my point. The defendants were required. The defendants, in complying with the provisions of paragraph 2 of this decree, and this is about the school choice stuff. But they had to comply. It was the defendant. So in 69, let me just stop this share real quick. The defendant brought forth a plan called, where is it? I got the name of it right here. A plan to eradicate all aspects of the dual school system. Hey, the dual school system meaning we got black schools, we got white schools. Needs to be there needs to be racial integration. So what's the plan? That plan cannot be found. I have a public records request about 2 weeks ago looking for this. On our school website is the order approving that plan. That means the judge says, yep, I agree with this. I sign off on it. Go execute plan. But I have no idea what that plan means, what that plan entails. Was there a negotiation with the plaintiff in that plan? Because this is something that's really important to the desegregation order. Right now, the plaintiff, which is the NAACP and not people, it's like an organization composed of people, obviously, and the school system create their own plan. The 2018 Joint Action Plan, for example. That's what we have today. You read on the website that it says teachers shall be within 3 plus or minus 3% of the minority population. We shall have a minority teacher hire. That's out of the Joint Action Plan. It's been modified to say that. And so these things are always modified, updated, they're goal-oriented, they use data to validate, but it says we're never in unitary status. This is completely different than what we just read.
Right.
If you look at what we just read and applied it to today, we're at unitary status. And we can look at this stuff and see that the order that C. Clyde Atkins put forth, we are definitely in compliance with. You can go on the website and see all the data, minorities, teachers for each school, so on and so forth. You can see all of that and determine we have definitely reached unitary status based on what was asked for in 1967, based on what has been negotiated between the NAACP and our defense team, which is the superintendent, the lawyer for our school system, and a few others. No. And what do? They start creating these policies we talked about in the beginning to show the judge, hey, we're putting our best foot forward. But these policies are written in sort of the vernacular of the day, the legal vernacular of the day. And critical race theory has a big role in that vernacular. Sure. That's a problem. Because the racial equity policy, it says the school system's systemically racist. Well, it's not the buildings. We've built them all out to be equally suitable. No matter where you go, we got a great school. Whether it's Dodgertown, Vero Beach High School, wherever, Osceola Middle, they're all great facilities, up to the standards, and constantly improved. So those things are great. But they're not asking for that now. People aren't asking for that. They're asking for these things. They're still saying the school system's systemically racist. That tells me that you believe people are. But we have an anti-discrimination policy that says otherwise. Actually, this racial equity policy runs counter to that. And according to the 67 order, we're fully integrated. Where does that leave us?
Right. It shouldn't be still continuing on almost 60 years later. That's right.
Absolutely. And I think that's what we need to talk about, because there is this gap. It's not a gap. There's not a gap of, there's not a lot of court activity in that 30 years. And I don't see many reports back to the judge. So in 1994, this same judge, C. Clyde Atkins, sits and they hammer out the 1994 joint plan. And the NAACP has now become the plaintiff. And that changes everything.
In 1994?
Mm-hmm.
Yeah, okay.
And so you'll hear a lot of times we have the 67 order, the 94 order, and the 2018 order. And that 25 years between when the dual, the 1969 or it's plan to eradicate all aspects of dual school system was submitted and approved May 19, 1969, and to 94. What happened in between there? I can't tell you. I don't know how it was managed. There should be reports that were submitted to the judge. And they mostly did that with the integration of the schools. Every November 1st, they had to submit to the judge. Hey, boom, boom, boom. Mm-hmm. It's in that 67 order. This is what we're doing. And, you know, so that's a good question. And I see this a lot. The 2018 plan has been monitored very closely because we have work group committees and all this stuff. But look at Sebastian River High School. 7 out of the top 10 academic students were minorities. 2 out of the top 5 were African American. We don't have an achievement gap. Not this year. You know, no, we have people on both ends of the spectrum doing great or not doing great.
Right.
And here we are saying we're not unified or we're not having unitary status. It doesn't make sense.
Yeah, doesn't make sense to me from the outside looking in. So Yeah, so I guess we'll call it episode. On our next episode, do you want to talk about, maybe from '94 on and what's gone on, maybe for maybe another 20 or 30 years at that point, and just kind of bring people up to speed?
Yeah, I think of from 94 to 2016, 2018, where the joint action plan for 2018 is implemented. That's going to be the next thing because it's very important. And there's certain things in the 94 plan that'll help clarify how this whole case is being managed. So we'll do that next time on the Muppet Show.
Perfect.
Moms for Liberty
Thank you
show.
for all that information. Yeah, no, that's awesome. And it's good because it makes it real. And a lot of people haven't been following this or they don't know the logistics of it. So to hear it and have it broken down and actually see it, I think that'll make a difference for a lot of people to understand where we are today with it.
Cool. Well, let's do that. And we'll see you next time.